If you are a green card holder living in the United States, what you are about to hear in this video could directly affect your status, your ability to travel, and even your pathway to citizenship. Major changes to immigration law have just been signed into effect, and these are not distant proposals or political talking points anymore. These are real, binding rules that will begin impacting lawful permanent residents starting this year. I know how stressful it is to live with immigration uncertainty. Many of you have built entire lives here. You have families, jobs, mortgages, and dreams for the future, and when the rules change, everything feels unstable. That is why I created this video. Not to alarm you, but to make sure you understand exactly what is happening, what it means for you, and what steps you can take right now to protect your status. Stay with me through the entire video because I will break down every critical provision of this new law, explain who is affected most, and give you a clear action plan. Some of what you are about to learn may surprise you. And one section in particular has already caught many green card holders completely off guard. Let me start by setting the stage so you fully understand why these changes are happening now and what led to this moment. Over the past several years, there has been intense political pressure to reform immigration enforcement, processing times, and the responsibilities of lawful permanent residents. Regardless of which political party has been in power, one thing has remained consistent: the push for greater accountability for those holding green cards. This includes stricter compliance requirements, more rigorous background checks during renewals, and clearer rules around maintaining lawful status. The legislation that has now passed represents the most significant update to green card holder obligations in over 2 decades. And here is the critical part that many people are missing. This law does not only affect new applicants or those currently in the immigration pipeline. It applies to everyone holding a green card, including those who received their status 10, 15, or even 20 years ago. Now, before we go further, I want to clarify a common misconception. Many green card holders believe that once they receive permanent residence, they are essentially set for life, as long as they do not commit a serious crime. That belief has never been entirely accurate. But under this new legislation, it becomes even more important to understand your ongoing responsibilities. A green card does not guarantee permanent residence forever. It grants you the right to live and work in the United States indefinitely, but that right comes with conditions. And those conditions have just become more explicit and more strictly enforced. Let me walk you through the core provisions of this legislation. I will explain each one clearly and tell you exactly who needs to pay attention. The first major change involves continuous physical presence requirements. Under the previous framework, green card holders were generally expected to maintain the United States as their primary residence. Extended trips abroad, typically those exceeding 6 months, could raise questions during naturalization or re-entry, but the enforcement of this was often inconsistent. Under the new law, there is now a formalized tracking and documentation system for international travel. If you leave the United States for more than 90 consecutive days without filing a re-entry permit or documenting a qualifying reason for your absence, your return could trigger a formal review of your intent to maintain permanent residence. This does not mean automatic revocation, but it does mean you may be required to appear for an interview and provide evidence that you have not abandoned your status. This matters enormously for green card holders who travel frequently for work, who care for elderly relatives overseas, or who maintain business interests in their home countries. What was once a gray area is now explicitly defined. The second major provision involves the green card renewal process itself. As you may know, green cards must be renewed every 10 years. Previously, this was a relatively straightforward administrative process. You filed Form I-90, paid the fee, submitted biometrics, and received your new card. That process has now expanded significantly. Under the new law, all renewal applications will include a comprehensive background re-evaluation. This is not simply a check for criminal history. It includes a review of tax compliance, public benefits usage, and any prior immigration violations, including those that may have occurred before you became a permanent resident. Let me pause here because this is where many applicants are going to run into problems they did not anticipate. If you have gaps in your tax filings, if you received certain public benefits during periods when you were not eligible, or if there are discrepancies in your immigration file that were never formally resolved, these issues will now be flagged automatically during renewal. And if they are flagged, your renewal may be delayed, denied, or in rare cases, trigger a removal inquiry. I want to be very clear. This does not mean you will lose your green card for minor issues, but it does mean you cannot afford to ignore past problems and assume they have been forgotten. The third provision is perhaps the most significant for those planning to become U.S. citizens. The naturalization timeline has been restructured under this new law, and the eligibility requirements have become more rigorous. Previously, most green card holders could apply for naturalization after 5 years of continuous residence, or 3 years if married to a U.S. citizen. Those timelines remain in place, but the documentation requirements have increased substantially. Applicants must now provide a complete employment history, detailed travel logs, and proof of community ties such as property ownership, school enrollment for children, or long-term lease agreements. Additionally, the civics and English language examinations have been updated with new content reflecting recent historical and governmental changes. But here is what concerns me most. And this is the part I referenced at the beginning of this video that has caught many people off guard. Under the new law, there is a provision that allows USCIS to retroactively review any prior application you submitted, including your original green card application, during your naturalization process. If inconsistencies are discovered between what you stated then and what you are stating now, your naturalization could be denied, and in serious cases, your green card could be questioned. This is not a theoretical risk. This is explicit language in the legislation, and it will be enforced. Now, I want you to consider something for a moment. Think about the forms you filled out 5, 7, or 10 years ago. Do you remember every answer you provided? Do you have copies of those applications? Did you work with an attorney who kept detailed records? Many green card holders submitted their applications during a time when they had less understanding of the process. Some relied on notarios or friends for help. Some made unintentional errors, and some simply cannot remember what they wrote because it was so long ago. Under the old system, those inconsistencies might never surface. Under the new system, they almost certainly will. This is not meant to frighten you. It is meant to prepare you. Later in this video, I will share specific steps you can take to protect yourself, including how to request copies of your immigration file and how to prepare for your next application. But first, let me explain who is most affected by these changes. The green card holders who face the greatest risk under this new law fall into several categories. The first category includes frequent travelers. If your work or family obligations require you to spend extended periods outside the United States, you must now keep meticulous travel records. Passport stamps, boarding passes, and entry logs are no longer optional documentation. They are essential. The second category includes those with complicated tax histories. If you have ever failed to file a return, underreported income, or claimed credits you were not eligible for, these issues must be addressed before you submit any renewal or naturalization application. The intersection between immigration enforcement and tax compliance has never been tighter. The third category includes green card holders who received public benefits. This is a sensitive topic, and I want to address it carefully. Many immigrants have received benefits legally and appropriately, but the new law requires a detailed accounting of any benefits received, and in some cases, repayment or explanation may be required before your application can proceed. The fourth category includes those who filed their original applications with errors, omissions, or inconsistencies. If you know or suspect that your original petition contained inaccurate information, you need to consult with a qualified immigration attorney before submitting any new application. And the fifth category includes conditional green card holders, particularly those who received their status through marriage. The new law includes enhanced scrutiny for marriage-based green cards, including expanded interviews and additional documentation requirements when removing conditions. If you fall into any of these categories, please do not ignore what I am saying. The consequences of inaction are too significant. Let me be direct about the potential consequences. If you submit a renewal application without addressing prior issues in your file, you could face extended processing delays that leave you without valid documentation for months or even years. During that time, your ability to work, travel, and access certain benefits may be compromised. If inconsistencies are discovered during naturalization, your application could be denied and you could be referred for further investigation. In serious cases, this could lead to removal proceedings. And if you abandon your residency by spending too much time abroad without proper documentation, you could find yourself denied re-entry at the border. I have seen this happen. It is devastating. But here is the other side of this. If you take these changes seriously, if you organize your documentation, address past issues proactively, and submit accurate, complete applications, you will be in a far stronger position than those who wait and hope for the best. Immigration success is almost always the result of preparation, and that has never been more true than it is right now. Let me give you a clear action plan. This is not legal advice. Only a licensed immigration attorney who has reviewed your specific case can provide that. But these are the general steps that every green card holder should consider. First, request a copy of your immigration file. You can do this by submitting a Freedom of Information Act request to USCIS. This file contains every application you have submitted, every decision that was made, and any notes or flags that may be in your record. Reviewing this file before you apply for renewal or naturalization is critical. Second, gather your travel records. Start now. Compile a log of every trip you have taken outside the United States since receiving your green card. Include dates, destinations, and the purpose of travel. If you do not have complete records, contact your country's immigration authority or review your passport stamps. Third, review your tax filings. Confirm that you have filed every required return and that your records are accurate. If there are gaps or issues, work with a qualified tax professional to address them before submitting any immigration application. Fourth, consult with an immigration attorney. If you have any doubts about your status, your history, or your eligibility, get professional guidance. The cost of a consultation is minimal compared to the cost of a denied application or a removal proceeding. And fifth, stay informed. Immigration law changes constantly. Subscribing to reliable sources of information, including channels like this one, is one of the simplest things you can do to protect yourself. Let me summarize the most important takeaways from this video. First, the new immigration law passed in 2026 represents the most significant update to green card holder obligations in more than 2 decades. It affects renewals, naturalization, travel, and retroactive review of prior applications. Second, continuous presence, tax compliance, and documentation accuracy are now under enhanced scrutiny. What was once loosely enforced is now formalized. Third, Green card holders with complicated histories, including frequent travelers, those with tax issues, or those with errors in prior applications, must take immediate steps to address potential problems before applying for renewal or citizenship. And fourth, preparation is protection. The applicants who succeed under this new framework will be those who understand the rules and follow them carefully. I know this is a lot to take in, and I know that for many of you, this information feels overwhelming. But knowledge is power. By understanding these changes now, you are already ahead of the majority of green card holders who will not learn about this until it is too late. If you found this video helpful, please subscribe to this channel and turn on notifications. I am committed to bringing you accurate, timely immigration updates so that you are never caught off guard. In my next video, I will be covering the new naturalization interview process in detail, including the updated civics questions and what adjudicators are now specifically looking for. You will not want to miss that. Thank you for watching. Stay informed, stay prepared, and take care of your future.